Gary, the faith being expressed that the series of suits coming up are likely to stop the Speaker from granting, a recall, suggests to me that the allegation that the judiciary is losing a lot of trust may not be true. Because some people believe that there are fresh suits and those suits could determine the other way around against the majority.
You see something, this issue, I'm happy that you commence it by stating the position of the law. You see, I always say that it is immaterial whether you belong to political party A or B. On matters of law, that the public know that this is the position of the law. So when you said it, and my brother Kofi Adam said he doesn't agree with you, I forgive him because he's not a lawyer. But when you indicated that once the Supreme Court has spoken and put a stay of execution on the order of the Speaker, the majority side remains as it were, the majority remains as it were. What has brought us to where we are now? In my view, my humble view, I think that Right Honorable Speaker Bagbe will have saved the country all this brouhaha by simply staying his hands off and proceeding at the time when the writ of summons and the injunction application was served on Parliament.
On the 15th?
Yes.
Nothing was served on.
Before they took the decision.
You see,
it was ex-party.
You see,
they had not been served. That's
talking about no service on Parliament.
You see,
there was no service on.
So it's okay.
You see, I have in my hand here a letter that was written on the 18th of October, 2024, under the hand of Mr. Ebenezer Ahuma Jetro. Is it called Jetro or Jetro?
Jetro.
Jetro? Okay. Now, this letter seeks to show clearly that the injunction process and the writ was served on the House.
Show us why.
I should read the letter.
Show us why it shows that the House was served on the 15th.
This letter is addressed to the Registrar of the Supreme Court, Accra. Dear Registrar, writ of summons 18th of October.
Okay.
2024.
A day after the Speaker made the declaration of the ruling.
The ruling. And you see, let's approach my with sober heads. That's what I'm saying, that it will have saved all of us the trouble.
So let's
now, I am directed by the Right Honorable Aban Sumana Kingsford Babe, Speaker of Parliament, to return the attached processes which was left at the Legal Services Office of the Parliamentary Service by 3 bailiffs of the court on Wednesday, 16th October 2024. Attempts were made to set the same processes on Tuesday, 15th October 2024. Right Honorable Speaker notes that the attempted service is contrary to Article 117 of the Constitution and the circular issued by the Chief Justice, by Lady Cecilia Pamela C.A. Cranton J., that's the Justice Secretary. Then they say, consequently, Right Honorable Speaker had directed the return of the attached processes for a necessary action. Signed, Ebenezer Ahuma Jeto. This letter now attached the processes, which was an injunction application, which was filed, which was seeking to hold the Speaker's hand to proceed to give a pronouncement on Article 97, okay, and it was returned back to the Judicial Service. Sometimes we should hasten slowly. You are just saying that because you were not served on the Monday as directed by the CJ in its party direction, you are returning the processes back to the Judicial Service. What stopped the Speaker from just simply saying, yes, I'm now seeing the writ of summons with accompanying claim and the injunction application, seeking to hold my hand to say that the very thing I want to proceed to comment on or to give a ruling on. So therefore, I'm holding my hands to abide by what the Supreme Court will say in respect of the interpretation of Article 97, G and H, which is a new area altogether. Now, let's not forget, the Speaker has placed, the Speaker and the NDC side, they have placed a different meaning to the provision. The NDC side have also placed a different meaning to the provision. Speaker and NDC are simply saying that the filing of the nomination by these people at the EC amounted to a vacation of their seat. That's what they are saying, that the filing of the nomination at the EC amounted to a vacation of their seat. To the others, they understand of it. Majority side is also saying that the mere filing did not amount to a vacation of their seat. However, vacation of the seat will happen if and only if those members of parliament actually physically move from where they are to the minority side.
In parliament.
In parliament. So clearly, an issue of interpretation has what? Arisen, because they are put rival meanings.
So before we proceed on that, Article 117, it says civil or criminal processes coming from any court or place out of parliament shall not be served on or executed in relation to the speaker or a member or the clerk of parliament while he is on his way to, attending at, or returning from any proceedings of parliament.
Yes.
So was this service, Speaker Babin recognized this and said they attempted to throw it on the legal officers of the house whilst they were working.
You see, it is a difficulty of the implementation of the provision that you just cited. That is why Parliament and the Judicial Service now have to do what they call a party direction as to the mode by which, please, can I...
That services will be done on Mondays.
On Mondays.
Because Mondays they don't sit.
Good. Now, by this letter, what it means is that the Speaker of Parliament was seized with the facts of the writ, was seized with the facts of the injunction application, and he was fully aware that this is what Afanya Makin was seeking to do, and yet proceeded to do what he did.
A while ago, you commended me for commencing on a note of being direct and plain about the law.
Yes.
In the face of Article 117, did the Speaker do the right thing, that they had not been served, or you will say they were served?
You see?
No, can we answer that?
No. They were served.
They were served?
They were served.
The Article 117 says, civil or criminal processes coming from any court or place out of parliament shall not be served on or executed in relation to the speaker or a member or the clerk to parliament while he is on his way to, attending at, returning from any proceedings of parliament.
Yeah, you see something. That's why I'm saying that it is a difficulty of the implementation of 117. That is why they all agreed on what they call...
Let's pause on the difficulties for now. In the face of this provision of the law,
yes,
was there service by taking the processes, going into parliament whilst they are working and seeking to throw the processes on them?
Is it say they were working?
Yes, they were.
Parliament sat on Tuesday.
They were.
They were working.
Yeah, they were sitting.
On Wednesday, we sat.
You see, something. Let's get it very clear.
Was it service?
No, listen.
No, you.
So the service, hold on. Let's even assume that the service was even irregular. Okay, it was even irregular. Assuming it was even irregular. The contents of the writ and the injunction application has been brought to the notice of the Speaker. Is that not right?
Is that proper? Is that the way to do it?
I'm saying that, assuming the service was even irregular, let's say the service was even irregular. Let's agree that it was even irregular service. That you are looking at 117 and expecting that you must strictly apply to 117. The point I'm making is that the contents of what you want to do has been brought to your attention through the writ and the injunction that, look, please hold your hands on the interpretation of the Constitution. And let's wait for Supreme Court to give us interpretation. We all agree.
So when it comes to interpretation, let's move beyond that.
Okay.
Even though this is too plain, let's move beyond that. Do you think that if that were to be the standard, can you foresee the mischief? Parliament wants to do anything. By any morning, somebody goes there, throws documents at them, and says there's an injunction application. Not that a court has given an injunction, there's an injunction application, so stop. The next day, Parliament wants to do another business. Somebody is not happy about it. It goes to the court, files a process in the court. It has not been granted yet, comes to serve on them. What do you think?
You see, Samson, you and I know that when you file an injunction application, and the application is seeking to halt an activity, that activity is contained in the writ of summons and the claim. And you say, please stop. And the person proceeds to do the very thing that you are complaining about. That is service contempt of court.
That's not my question.
What is your question?
Do you foresee the problem with Parliament if what you are proposing works? Tomorrow, Parliament wants to do something. I don't want them to do it. I'm not happy about it. I go to the court, I issue a writ, I add an injunction application. It has not been heard, nothing. I go and throw it at them. The next day they want to do another thing. Somebody doesn't want it. Goes file something, throws it at them. They should stop, they shouldn't work.
Oh, I don't think that you see, now you are going too far. You see, now you are going to absurdity. That, you know, people just issue frivolous applications and then we just go to the servant of Parliament. I mean, now you're going too far. There is a matter where an issue of interpretation has arisen. And it's a matter that you and I know that 97 has not been interpreted before. It's a matter that the two parties, including the speaker on the NDC on one side.
I don't want us to talk about that. I've seen you are just evading my question.
I'm not evading your question. I'm not evading your question. I am saying that, you are going to an absurd situation. What you are saying is an absurd situation. That, anytime one people don't do anything, then you go and hold them. That's you an absurd situation.
So you appreciate the purpose of the arrangement between the Parliament and the judiciary?
I do.
That if you have to serve things, serve them all.
I do, 100%, I do. The only point I'm making here, for all of you to understand, is that the very thing that he was seeking to halt, he was aware. And yet gave his ruling, which he said is a comment, his ruling on the matter, and now it's confusion. People says they have stayed it. He came to Parliament, they didn't indicate that because the Supreme Court has stayed the ruling, that is the reason why I'm adjourning. Rather came under a different order, they said, well, in the public interest, and I'm now adjourning the matter. Okay. I sincerely believe that on the matters of the law, as complained about, if a member of Parliament who is there for 4 years, certain, has not physically moved from his side, that is NDC side, to MPP side, in Parliament, I do not think that you can say that member of Parliament indeed has crossed carpet. Cross carpet simply means that, or it means you have changed the character of how you come into Parliament by physically moving from where you are to a different position in Parliament, not by your intention. How are you going to rule intentions? Your future intentions. This is what is future intentions. So for me, I
wish
think that
we don't relitigate Article 97(1) because we have spent time to educate our listeners on it and our viewers on it last week. But since you are still bringing it up, let's read it to our viewers one more time.
Very well.
Article 97(1) says, a member of Parliament shall vacate his seat in Parliament. Shall vacate his seat in Parliament.
Yes.
Correct?
Yes.
That is mandatory.
That's correct.
You have no option in it.
Oh, you have no at all.
It says you shall vacate your seat in Parliament if these things happen. Parliament is dissolved. If the person is elected as a speaker. If the person is absent without permission from the speaker as required.
Blah, blah, blah. So let's go to the contentious ones.
If the person is expelled from Parliament.
Okay.
Then when you come to F, it says if the person resigns as a parliamentarian.
No, there's no question about that.
G,
and I'm expecting
if he leaves
Parliament tomorrow.
G, if he leaves the party of which he was a member at the time of his election to Parliament to join another party.
Good. Now,
or seeks to remain in parliament as an independent member.
Yes, let's break it down.
If you leave your party.
Let's break it down.
Okay.
Let's break it down. So that you see, as you said, for the education of our
right.
viewers. If he leaves the party
that brought him to parliament.
How do you leave a political party?
Yes.
Leave a political party by writing a letter to indicate to the party that you, so and so and so and so, you're a member and you have left the political party.
You must write a letter.
You must indicate that you have left the party.
Wait.
This constitution.
Hold on. Adam, hold on. Yes. Please hold on. Go ahead. Yes.
The other one is what? The second leg is what?
The second leg is, or you seek to remain in parliament as an independent member.
These members whose conduct is now brought.
The Bold Safety Team, by your side on every ride.
Of parliament, the answer is no.
They want to become next parliament.
In the next parliament, they've expressed their future intention that in future, 2025.
So you know their intention.
That's an intention. They've expressed their intention.
You were saying it's difficult to find the intention.
No. I'm saying
if they have not physically moved in parliament from where they sit to join the other party.
No. You see,
if you declare yourself as independent,
yes,
in parliament, where do you move and go and sit?
Independent, when they come, they always have to join the one side. Either you want to join the majority side or join the minority side.
So Esiama, where should he have moved to?
Esiama should have moved to the minority side. Let me decide.
Okay. That's the only time that this law applies.
You must physically move. You see, you must physically move.
Okay.
Because if you say that you have declared an intention to go for future elections as an independent candidate, or you want to now go, join a political party in future, but you have not resigned from your political party.
What Ghanaians are asking you now is,
yes,
Makokwe did this. You were happy about it. Why now?
You see, Mr. Makokwe did it. I was happy about it. I didn't comment on what Makokwe did. So why do you say I was happy about it? I didn't comment about it. Did you hear me comment about what Makokwe did? I didn't comment.
Did he do right?
In my view, the question of interpretation is the exclusive preserve of the Supreme Court.
Did Michael Quay do right?
I will not say to pass a judgment on Michael Quay. He was my professor of political science. I'm not sitting here.
So you don't know if he did right or wrong?
I am saying that what Michael Quay did at that time, by seeking to interpret the Constitution in Parliament, is a preserve of the Supreme Court.
Okay. So here, you said you need to write a letter. This is a letter written by Justin Kodua Frimpong on the November 20, 2023.
To who?
Let me read and you get to understand. It says, it's headed Forfeiture of Membership pursuant to the provisions of Article 391 of the New Patriotic Party Constitution. The leadership of the New Patriotic Party has taken notice of recent activities of Hobson, Adoye, Yabuabeng Asamoah, Nana Ohene Nto, and Boniface Abubakar Sadiq, which includes publicly endorsing the candidature of a person other than the duly elected presidential candidate of the party, His Excellency Dr. Mahmoud Bawumia, in spite of their flagrant breach of the party's constitution. Then it quotes blah, blah, blah. The aforementioned men still hold themselves out as members of the NPP. For the avoidance of doubt, then they refer to the particular article and then come to say, in line with these constitutional provisions, it is the view of the NPP that Hobson Adoye, Nana Ohene Nto, Boniface Abubakar Sadiq, and Yabuabeng Asamoah have automatically forfeited. Automatically forfeited is in caps. Their membership of the party. They are therefore no longer members of the party.
Thank you. I'm happy that you quoted NPP Constitution. But you didn't quote National Constitution.
No, you said you need to write a letter to show that you have left the party.
No.
Did these people write letters to the party?
Well, this is a situation where the General Secretary said he has taken notice of the activities of these persons, and so therefore the membership is forfeited.
And they did this on your advice because that's your job.
This is the operation of the NPP constitution. Okay?
It says,
MPP constitution. Oh, Sammy, can I?
It says what? The constitution says what?
Can I finish?
Go ahead.
MPP constitution is subservient to the national constitution.
Okay.
This thing we are talking about here is an issue of national constitution.
So does the MPP constitution require you to send in a resignation or a letter before you are deemed by the MPP as having forfeited your membership?
Well, sometimes your activities can show. We must dismiss you. You can even be dismissed from the party. Yes.
Okay.
On the party. I'm saying that in this instance, even though the conduct of these MPs, to me,
I'm holding NDC's constitution.
It's impugn.
This is a copy. I'm holding MPP's constitution.
is it the amended one or this is the old one you are holding?
This is the amended. So
This
actually,
amended
this one is not Article 3. This one you find in Article 9.
Hold on.
Forfeiture of membership. I want to read something to you.
Hold on.
I want to read something to you. Forfeiture of membership. It says, a member of the party who stands as an independent candidate against the officially elected member of the party, or who joins or declares, once you declare, you are caught, who joins or declares his or her support for another political party or for an independent candidate when the party has sponsored a candidate in a general or by-election, automatically forfeits his or her membership to the party.
Yes, this is the MPP constitution, and I agree with it. Now go to the area where it says a member shall not lose his right for membership unless he has been heard. In the constitution of the MPP. It's there.
Where?
Boniface, Abubakar, Sadiq, all these people, were they heard before you issued this letter telling them that they have automatically left the party because they have declared for Alan Chamating?
You see something. The constitution should be read as a whole. You don't pick and choose the portion that favors you and use it. No. It should be read as a whole. I'm saying that this constitution of MPP, if you read it as a whole, you ought to hear a person before you take certain actions against the person.
When the party wrote to Michael Quay, did the party hear Mr. Esiama before they wrote to Michael Quay?
Esiama, well, at that one I cannot.
They did not. They did not,
right?
Yeah.
Okay, I can confirm that, but I can't be sure. But the bottom line is that let's understand something. This is the first time in this party's history, as far as I'm concerned, that we have been doing primaries in the party, and post the primaries, you have litigation in court, several cases in court, sometimes 46 cases, sometimes 30 cases. We have the case of the country resolving cases.
Yeah.
In fact, this year was the only time that the party went for primaries. There was only one case in court, of which you were involved in that matter. Okay?
Yeah.
Only one case. Only one case. Everybody who took part in these primaries was given the full opportunity to take part freely. You will lose, you will win, you realize that you have actually participated fully without any inhibition at all. It's the first time. And that case, that even happened enough. That was the only matter that became a matter of a court suit. So for me, if you go into a primaries and you lose, and then you decide, having lost the elections, you want to go as an independent candidate against the party's nominated candidate, to me it's an unfair decision against the party.
Okay, I have one more question for you.
It is not right.
So I need us.
It is very, very wrong.
I need us.
But that doesn't mean that they have also lost their right to stay in parliament.
I need us.
But they have not said they have crossed carpet.
I need us
physically in parliament.
I need us to move on. But because you brought in the Walewale case, let me tell you one interesting thing. Why some people have issues with the courts. In the Walewale case, the judge came out and said, this person case has won. This person has lost. He didn't read anything. And he said he did this on Monday, September 2. And he said that the judgment will be ready September 12th. As we speak, we have written to the court many times. The judgment is not ready. This is some of the things that dips people's hope in the courts. Now the question I'm asking you here is
that could be an isolated case.
Isolated.
Which reasonably.
Okay.
I will not agree that you give a date for judgment and then you don't deliver the judgment. Maybe there may be a reason for that, but I think communicate why the judgment is not ready. Okay. That notwithstanding, I think there has been elections there and your candidate has still won.
Well, this has just also happened. I think the PPP case, the judge dismissed their case. There's no judgment for them.
Which of the cases?
I think PPP, they've been dismissed. They've been disqualified from the elections
Yeah, the recent
standing. Yeah. Okay, but this is the question, and I need us to move on.
Right.
This is the question. It's about whether you think the approach to compel the speaker to call parliament will work.
You see, it's two things. It will work if the Speaker of Parliament is willing and ready to accept that in this country there's something called rule of law. Rule of law. And there's something called constitutional supremacy, not parliamentary supremacy. And the only body that gives orders to this matter, the Supreme Court, giving these orders, which the failure to obey or amount to a high crime, I think the Speaker, if he's going to obey that order, pending the determination of the suit, should obey the order.
The order is not that you should call parliament. That's not it.
No. But when you call parliament, there's a grey line here. Where do majority sit? Where do the majority sit? At my last check, NDC says that they are the majority.
So they are sitting on the right-hand side of the speaker?
Yes, and to the extent that even when the hazard was even being corrected and all that, Esosu made a point that the speaker, he think that was referring to a minority, not majority. It was so corrected. And I was listening to it on your network.
It was not corrected. The speaker said, let the department check the records and let it reflect what exactly
it was. Very well. So now when the parliament is recalled, and the last time we saw them go to sit at the majority side, and you see Honorable Fenyamaki also came, the came also, they want to sit at the same place. Look at the chaos that will have, engulfed parliament. Should these honorable men and women go to parliament and they are struggling for the same place? I think speaker should be bold and tell all of them that I'm the Speaker of Parliament. This is my chamber. This is my house. I have to regulate all of you and what you are doing. The court of Ghana, the Supreme Court for that matter, has stayed my ruling. And so, I am ordering that majority be at where you are or where you were, minority be at where you were, so that we can conduct business until the court determine the matter. For all you know, the court may be able to deal with this matter in a very efficacious, quick manner, and this matter will come to an end. If the court comes to a conclusion, the speaker was right.
No, my issue now is,
yes,
and the question is about this. He's being compelled to call the House. Many, including Dr. Rashid Draman, is saying the solution is not a legal solution. It is rather sitting together to talk. You know the speaker can recall the House today and adjourn it the same way he did.
Yes, I agree with you.
And then you force him to call again. He can call again and adjourn the next day, even though that will be,
I think the issue,
that will be irrational and abuse of discretion.
I think the issue to me is both legal and political. The tempest must come down.
Okay.
I think the tempest must come down. We must find a diplomatic approach to be highly diplomatic in both minority and minority being NDG side, majority being MPP side. It should find a way to navigate these steamy waters. You see, some of these things.
So why do you go on with a compelling process just a day after he calls he adjourns indefinitely, rather than seeking to talk with him to see if you can agree?
You see, I'm saying, you look at the quick manner with which the minority side were trying to form committees, the quick manner which they were trying to now
repeal betting tax, repeal e-levy.
When they say betting tax, you know I'm the board chairman for NLA, and I was board chairman for giving commission. So,
okay.
You know, for me, I think the speed with which they were trying to change things, they necessarily require that Afenyo do something about it. And for me, I think the Supreme Court saved the country by bringing the status quo to stay. The country. That's why I see they save the country, because if they have taken these steps in that quick manner and started to change a lot of things, look, something. This is a serious governance matter.
So why do you go to the House that day so that there will be sufficient numbers to take decision? Because they didn't go there, you didn't have half of the members. That's why the speaker adjourned.
Yes.
If they had gone in there, you would have had half of the members at least, so Parliament can go on with its business.
I think that, you see, even before Parliament is record. There has to be serious discussions, majority side, leadership with the speaker, using cool heads.
Okay. Kofi,